Okay, Kevin, thank you so much for coming on to the Security Space podcast. Today, what me and Kevin will be speaking about is all about international data compliance. And obviously, before we get into it, Kevin, do you want to make a quick introduction to yourself?
Hi, I'm Kevin Tunison, Data Protection Officer with Egress Software Technologies. I've held security roles in fraud, education, and public sector over the last 15 years, and now take a focus on international data compliance.
Perfect. So, what better way to start than obviously, giving a bit of an overview. And what we tend to do on the Security Space is we always do tend to start off with a bit of a definition. So, when we're talking about international data compliance, could you actually define what a data transfer actually is, please?
Yeah, like how we're starting off with the definitions right away. So it can mean lots of different things to different people. And the way we define it is the sharing of personal information that goes to a different legal entity. So that can be either a processor, like when Microsoft is providing you an email service, or it can also be a sub-processor, which is like a subcontractor. So that could be the anti-malware solution that Microsoft may employ while they're delivering the email service. So that's the general definition of data transfers. There is some slight variations to it. So not all transfers mean the information is disclosed. That would be relevant, for example, in Canada with the PIPEDA Act. They view disclosure as separate from transfers. So what that means is that the disclosure would be viewing the information as opposed to handing the information off in an automated fashion for a subprocessor to deliver a service. So,
okay. So to check my understanding on that then, so does data transfer, does it stay consistent across different countries, or like you say, Canada's a bit different? Is it different anywhere else?
Yeah, so with the transfer of data, you'll also have some restrictions that can happen as well. You have this notion of data sovereignty, and we might touch on this a little bit later in the podcast since we've last spoke. Anyone who keeps abreast of privacy-related developments would appreciate that the TikTok CEO had just appeared before the U.S. Congress, which had been a lot about data sovereignty. So when you look at countries like Australia with their healthcare, it will be restricted from any kind of transfer outside of that specific jurisdiction.
Okay, so just bringing it back to obviously the UK, because obviously a lot of the audience that will watch this will be UK based. What is a data transfer like in the UK and international data as opposed to maybe the EU as a result of Brexit? What was it like beforehand, and what did Brexit do to our data compliance?
Yeah, okay, great. So with that, I think that the main challenge with Brexit is that it's muddied the waters on what GDPR means, because you now have two separate pieces of legislation that, for all practical purposes, say pretty much the same thing verbatim. And I think at the moment that is likely to change. There's some legislation that's been proposed in the UK to revamp and overhaul the data protection laws. But I think the end result is that it's going to introduce more complexity and overheads. So you may find that the UK has a different assessment process that we make use of called an international data transfer agreement. There's a mouthful. And that's different from the EU assessment process, right? And the EU assessment process is much more prescriptive. And I think what we see in the UK is there will be a more a qualitative approach that's aligned to risk. And that will depend on the sensitivity of the data that you're assessing for moving around or choosing a subprocessor to engage with. So both of those, they factor into protecting human rights. That's the underlying foundation when you're looking at the variations of the law. All data protection law is for I say all, most data protection law is underpinned by the Convention on Human Rights. So how do people navigate that? And I think that the main thing is that you have to be able to pull on the power of the internet and social media and bringing in the services and skills from whatever jurisdictions you're working with. That's going to be huge. So you look at platforms like LinkedIn, and that's just one of many examples where people have these discussions on a daily basis. And I think that's going to help shape the legislation as it's working its way through Parliament. We've seen that last week when the House of Lords started to put their minutes online. That was discussed pretty quickly afterwards on LinkedIn, and what those questions can mean to the overall progress of this revised data protection bill.
Yep. And just two questions that I've got off the back of that, Kevin, is the first one, with this whole international data compliance and with data moving between different jurisdictions, like you say, who actually is overseeing and governing this? Should there have to be sanctions given out? Is it country A? Is it country B? Is there a unified body? Who's actually sanctioning this?
That's a great question. So there's a mechanism built within GDPR, and this is going back to the muddying of the waters with Brexit. That mechanism meant for any country that's part of Europe has what's called a supervisory authority. So that's like the ICO, but they'll have different names depending on the country you're in. The business where they have the main practice in. So for example, Google's main presence is going to be in Ireland, or maybe it's Belgium. Then that supervisory authority for that country will be expected to take the lead role in resolving an international issue. They don't always agree on who should be the lead supervisory authority in some complaints. So for that, that's where the European Data Protection Board will give some advice on who's going to be the lead. Now, with the ICO and the UK being out of the European Union now, none of that recourse exists in the same way. So we're reliant on our own sovereignty to decide how a particular business is going to be affected by international legislation. You have the same thing with other countries that have adequacy decisions. So what that means is that you have less administrative overhead in terms of the contract that you put in place if you're a data adequate country. The UK only has one at the moment, which is with, I believe, South Korea. And there is some work being done to arrange a data adequacy decision between the UK and the US.
Yep. Okay. Thanks for obviously cleaning that up. And am I right in thinking that you, or even Egress, that you guys are an international company? Am I right in thinking that you're based in? So obviously, Kevin, if you were managing people sort of remotely on an international basis who are spread across the globe, using that follow some methodology, maybe not. So what's some of the challenges that you guys face in this context, in the sense of, you know, sharing data and the different legislations that each different country has?
I think the biggest challenge is understanding various jurisdictions' appetite for applying what I'll call a absolutist approach to interpreting the legislation. Laws are put in place to protect people by and large, right, and keep society safe in general. But the application of the law does vary between countries, and that ends up being quite a tricky challenge to address when you're trying to enter into new markets as a small, medium enterprise that's quickly growing. I think we have to pull lessons back from large tech that have already went through a lot of these challenges. I think also one of the challenges is how legislation then gets shaped and implemented. You'll have varying degrees of how companies will get caught out by data protection legislation. So for example, there's a law that was written in, I believe, the late 2000s, maybe early teens, in Illinois called the Biometric Information Privacy Act. Nobody heard of it. It never had any use until about 7 years ago. And at that point, an attorney general seemed to pull it out the door, blew off the dust, and then decided this is actually really important. And they started to apply the legislation to companies like Clearview AI. Now, Clearview AI, if you're unaware, they are a facial recognition technology company that provides that service to the likes of military. Illinois had taken that biometric law, applied it to Clearview AI, and said you're no longer allowed to take any information of any citizen in the state of Illinois. So they effectively removed their license to operate in that state. And that was the first, I think, you've ever seen that. It could happen with GDPR in the UK or wider Europe, but that has never been used. So it isn't just about understanding where financial penalties can come in for an organization, but whether or not you actually be allowed to operate.
Yeah, and you've mentioned there that a couple of times that a lot of these big techs they are sort of US based. So do these companies have a duty to first follow US law? Is there a little bit more? Is bias the right word? I'm going to use it. Is bias the right word? So obviously, do you know where I'm going with that? Do they have to? Is it kind of a bit US centric?
I think that the European Digital Markets Act is a tool being used to help balance the playing field on technology and innovation and startups. And it is going to be interesting to see how that plays out. I think when you're looking at having a US presence, it can be tricky because you then have an obligation to follow US law. Now, sometimes that goes the other way when laws are extraterritorial. So with GDPR, if you don't even have a presence in the European Union as far as your business goes, that law still applies to you if you're targeting citizens within the union, or for UK GDPR, citizens within the UK. That law is global. So I don't think the courts get a lot of testing of this kind of case law very much, but there are some. So one example is FinGen versus Zscaler, and then also on Soriano versus Forensic News. That one was particularly interesting because the advertising for the Forensic News organization wasn't targeting EU citizens, but the actual case took place in California, and it was considering the scope of GDPR for that case. So I think it isn't just a matter of whether or not you want to enter the US as a market, it's how you're operating as a business and where those consumers or individuals reside.
And that's the big part of it, isn't it? It's where it resides, and that's where the data is kind of like held, isn't it? So in terms of you being a manager of people in security, talk to me about efficiency versus sort of legislation, because it sounds like it can be a little bit of a yin and a yang, and like in some areas you're like, yep, we're all good, like we can get this project over the line and it'll all be fine, but then obviously for your team based elsewhere it's like, oh, we won't be able to do it in them practices. So how do you not sometimes bang your head against the door where you're like, oh my god, like how am I going to do this on all fronts, or does it always, is there always a way of getting it over the line? It just sometimes is a little bit more extra hours on the clock.
That's a good question, Nick. And I think for any of your listeners or viewers, there is always a question of outstanding legislation and the fear, uncertainty, and doubt that comes from these cases such as Schrems 2, and whether or not you're able to lawfully have data transfer across international boundaries. Now, where I think that gets to be a challenge in terms of efficiencies, as we're talking about, but also innovation, you tend to find the majority of the innovation that comes out of the US has saturated much of the globe. I'm not saying that's where all innovation takes place by any stretch. There's fantastic innovation that comes out of all countries. But I think when you're looking at how we take an existing solution, there are examples where legislation in Europe or possibly the UK will apply restrictions that may not help innovation. So, for example, I think in a couple of years' time, all mobile phones will have to have a USB-C adapter as opposed to like a lightning plug with an iPhone. Now,
to be honest with you, Kevin,
yeah.
just to come in there, I've always been a Google Pixel man, and I get slandered off all my friends who are all iPhones. But here we come, here we rise, the USB-Cs. But please, sorry, continue.
There you go, man. There you go. Just have a look at their privacy policy, man. Yeah. Another example, and this will be relevant to marketing because that's where most of the Schrems 2 challenges come around when people want to say, well, if I'm going to transfer data to the States and or I want to use some kind of analytics tool, but it's US based, there are alternatives in the marketplace. So for example, pardon me if I'm not pronouncing the organization's name right, but Matomo. So they offer a GDPR compliant alternative to Google Analytics. That's awesome. But the entire business model, from what I can understand, is based as being pitted as an alternative to Google Analytics. So my question is, when Google Analytics creates a new innovative solution to how they provide their product, what does that leave Matomo with? Where is their innovation going to go? Is it always going to be on the coattails of existing big tech, or will they start to develop their own innovative solutions? And I don't think we see enough of that in Europe. And perhaps that's where the Digital Markets Act I mentioned earlier will help try and level the playing field.
And just to go back a step, just to check my understanding. So you've mentioned Schrems a couple of times. Are you right just to sort of, it might just be me, but are you right just to explain a little bit more about what Schrems are, what they do?
Yeah, sure. I should have explained that before. Maximilian Schrems is a privacy rights lawyer who had challenged that transfers of his personal information via social media platform, I believe Facebook, was unlawful, and that it wasn't complying with the GDPR. So that ended up getting challenged, and it resulted in the case being heard by the European Court of Justice, who sided with Max Schrems, saying, yeah, those data transfers aren't lawful based on GDPR. So in theory, that means those transfers, as they were, needed to stop because the US was no longer considered giving adequate protection to people's personal information. And that has now been the case for a number of years. There's been a couple attempts to resurrect data adequacy, but so far those have fallen short. And it seems until there's a congressional law put in place, privacy rights advocates such as Schrems will continue to challenge any kind of adequacy decision through the European and UK courts.
Okay. So, do you think we're ever going to get to a point where everyone plays along with just GDPR, where we can just standardize it across the globe, or do you think there's just too much socio-economic politics that will just be like, no, our version's the better one? What do you think to that?
Speaking very frankly, and I'll say there's a lot of money and time and bullshit. And what I mean by that is there's all kinds of different interpretations of what's okay, what isn't, and some of it's hypocritical. So while we're talking about all this stuff that happens in the States, you have national security laws like FISA and the Cloud Act. They create secret courts. Those are kind of chilling because you never know these court things happen. Now, everyone seems to be relatively aware that there's a large national security apparatus in the US. But do we ask ourselves, does the UK have the same in terms of UK national security laws, or EU for that matter? And surprisingly, the answer is yes. They are just as pervasive in the ability to monitor systems. So what's different? The difference is that when we're looking at Schrems, it focuses on commercial business, okay? But where this argument crosses over is it's about surveillance capability in the US and whether or not it's violating your human rights. Great, all right, so what does that actually mean? It means that wherever you are, you can be monitored. As a US citizen, including myself, I can be monitored because I'm not physically resident in the States at the moment. So that's one of the issues. Now, with having these different security laws in all these different countries, why then does GDPR not get the same rough ride? And it comes down to the European Court of Justice having looked at countries like Germany and France and others and their own secret courts actually being okay. Well, why was it okay? And the reasoning was it's okay because they're part of the European Union, which I find a little perplexing, and perhaps someone that's a better expert on the matter can explain why that's okay. But I think it just comes back to having a double standard, and I would love to see that be addressed. And I think until we have an open conversation around these underlying principles across countries where there are national interests at play, then we'll continue to find us at loggerheads with coming up with something that's effective for everybody.
Yeah. And if I had to put you entirely on the spot, because it sounds like there is, obviously with international data compliance, it sounds like there's no one size fits all. Everyone in the different regions, they all think their version's the better. Do you sort of look at it like the UK version's better, or do you think the US version's better, or do you think there's somewhere else where it's like, actually I like that version of that, so I'll take that for my own? I actually think that's the best. I think the US do that part of the best. If I had to put you on the spot and you had to, you've been given the right to be like, right, Kevin, you're going to fix this mess for us. What are we going to do? What would be your one size fits all sort of view on things?
Oh, good question. And good question. Now, when it comes to coming up with a one size fits all, there are cultural nuances and differences, right? So what is going to work in one country is not going to work in another country. And that creates friction for multinational businesses to operate effectively. I think for the majority of data protection, GDPR has set a fantastic high bar. And for the longest period of time, it was the high bar across everything. But it is no longer the case throughout. So for example, if you affect your rights as a individual, say you want a copy of your access, a copy of your data to access or have your data deleted. In GDPR for the UK or the EU, that means you get 1 calendar month to do so, unless there's some extenuating circumstances. But that's no longer like the shortest time frame. There's other countries like Brazil, and these would be done in 14 days. Another example is where data protection law applies with GDPR, you have to be alive. The moment you're no longer living and breathing, GDPR doesn't apply to your personal information any longer. But you look at other countries such as Singapore, that personal data continues to remain personal data for at least 10 years after you pass away. So I think that there's going to be a mishmash of different data protection laws to come up with the strongest, but is that the right way to approach it? And I think not, because you'll have people who are very willing to forego their rights, knowing full well what they are. You'll also have people willing to forego their rights, not knowing that they actually have those rights in the first place. So it's a challenging question to answer. And I think we need more people to understand their rights and play an active role as a citizen to get a better idea as to like what does a good law look like in the UK. And we're now starting to see the UK's Data Protection Act that's making its way through Parliament challenge some of the existing precedent that UK GDPR and EU GDPR had set. So you used to have to pretty much assess most kinds of data transfers or how you handle data. If the proposed legislation in the UK passes, it's only going to focus on high risk activities with regards to personal data, which is great for your overheads, right? Because then you're going to save a lot of money as a business. But it doesn't necessarily mean you're going to capture all the things that you used to get captured. And do we know that's a good thing? Well, we won't until we try.
And so my understanding of that is that GDPR has become, whilst it was the front runner at one point, that it's become perhaps outdated, and just other legislations has just kind of caught up in loose terms. It might be a silly question, this, but can GDPR just not be updated? Like you say, what they're doing in Singapore, the data carries on until 10 years after their death. Can they not just update that, or am I just completely naive in that sense?
So you can update legislation. Every country handles this a little bit differently. GDPR was a series of improvements of previous data protection legislation that was agreed with international bodies. And the original one, it goes back to the European Convention on Human Rights, and the signatories to that span across the globe. So I think GDPR will exist for many years to come, but there are going to be limits in how it gets applied. And the main social issue we're having with that at the moment are with large language models. ChatGPT has created a huge storm of conversation around large language models. And is GDPR up to the task? Do we need separate legislation for artificial intelligence or large language models? And that's a very difficult one to address, because there's two things you're looking at there. You're looking at the science fiction aspect of, can AI become sentient, which creates its own slew of moral and ethical unknowns that you can't do a good job of creating some kind of rule system around it until you really know what it is. It's like trying to describe a bear to somebody who's never seen an animal before and explaining why that's dangerous to be in the same room as a bear. So I think when it comes to the artificial intelligence and where we're progressing with machine learning and the large language models, we do need additional legislation that helps set down some basic principles on the application of how that data gets used ethically and responsibly. And that, again, is going to be something that varies across countries.
Kevin, I think you've just uncovered our next podcast for when you come back on in a few months' time. But no, putting that aside, thank you so much for obviously jumping on, Kevin. You've been really, really insightful with sort of delivering this piece today. So if anybody would like any further information from Kevin, all his details will be in the video below. But other than that, thank you so much for coming on, mate.
My pleasure. Thank you.